application of SK Zimbabwe against the Secretary of State for the Home Department.
My lords and my lady, good morning. I'm going to address you on three topics. Firstly, I'm going to...
Just a moment to get our papers in some sort of order. We've been presented with 9 reasons, Mr. Hussain, which no doubt we can read at our leisure.
That was in response to my Lord Brown's request.
So these are your
I can't
introductory
need to
points.
try and read my note, which is almost certainly impossible.
Thank you very much.
I'm not in dictation mode, so can I just tell you that the first topic will be some points on the statute. The second topic will be some points on the policy, the manual and its implications. And the third topic is I want to seek to respond to 2 questions that arose.
Yes. Well, we've been through your written submission,
very great.
so we can take. I mean, you've got your 4 problems and your 5 further points.
We're very
so,
grateful
so this is supplement to that activity.
Yes.
Right.
On the first topic, we wish to emphasise that the 1971 Act confers broad powers whose exercise is regulated by policy instructions and familiar public law principles. And as you saw, and I'll just give you, if I may, some references to our case, just pulling some strands together, you saw from our paragraph 22 the reminder that this, of course, is the way the immigration rules themselves work. Paragraph 22.
Yes.
Odelola is bundle 12, tab 105. We see it also manifested, and if you turn over the page, this is our paragraph 27, in Schedule 2, paragraph 1(3).
That's the instructions.
Yes.
Word.
And that's where it's the immigration officers in the exercise of any of their powers under the statute. Now, there is no similar provision where it is the Secretary of State himself that is acting, but you don't need to tell the Secretary of State of the need to act in accordance with the policy instructions of the Secretary of State. The third strand, which you have seen, again, if we just turn over a couple of pages to our paragraph 40, is that this, in any event, is a recognised principle of public law. Lord Phillips, in Nadaraja, which is bundle 8 at tab 75, that's why, for example, departing from a policy is a failure to act in accordance with the law for the purposes of an immigration appeal. That's the Court of Appeal in AA Afghanistan, bundle 11, tab 95, paragraph 16. And just to complete this drawing together, I hope it's helpful, of strands, in our paragraph 34, public law principles are no different, they are no weaker in their substance and status than are implied statutory restrictions. You'll recall, Hardiel Singh is Mr. Justice Wolfe explaining some of the implied statutory restrictions on the power of detention, that's paragraph 33. But all public law principles, and Mr. Hussain kindly read you the passage I asked him to from Boddington, it was 171 at the foot of the page, quoting Page, bundle 7, tab 58. Lord Steyn explains the same point in Pearson.
Sorry, I'm losing you, Mr. Fordham.
The point I'm making, my lord, is our paragraph 34, which is that public law principles take effect as implied restrictions on the statutory power.
Sorry, where's the proposition for that?
The proposition is that all recognised public
Sorry,
law
the authority
duties,
for that?
The authority, we saw it yesterday in Boddington. It was at the bottom of page 171, G to H. May I just show you one authority that touches on this in Bundle 7 at tab 56. Bundle 7, tab 56.
This is Pearson.
It's a very familiar case. I know you know it very well, but if you turn to page 588, this is the principle of legality which applies when one is considering the parameters of a statute with statutory powers. And it's the citation of Cross at the top of 588. Legislators and drafters assume the courts will continue to act in accordance with well-recognised rules. Long-standing principles of constitutional and administrative law are likewise taken for granted or assumed by the courts to have been taken for granted by Parliament. Examples are acting reasonably and acting fairly. So at the bottom of that page, just below G, he's dealing here with procedural fairness. The premise was that Parliament must be presumed to have intended that the Home Secretary would act in conformity with the common law principle of procedural fairness. So the idea is that you act incompatibly with the power that Parliament has conferred on you if you breach fundamental public law principles. Academics would want to debate this for a long time as to whether this is the right way of looking at public law, but from the point of view of practitioners in the courts, it doesn't matter. What matters is that public law principles are no less powerful in their legal effect as the express or implied restrictions in the statutory power.
Sorry, is your proposition that if you act contrary to a particular policy statement at a given moment, that is for all the world as if you are acting contrary to a statutory rule to that same effect as the policy?
Yes, it is ultra vires. And that's because, as Lord Phillips explains, it is a recognised public law principle that the decision maker must act in accordance with the Secretary of State's published policy.
But you're really taking this line with reference, as I understand it, to Rule 9.91 and the manual, paragraph 38.8.
I don't need it because I've got the section.
I understand the rule
Yes.
you're following, but don't we really need to understand what the purpose of the manual is, the context in
Coming
which
there,
it's
I
intended
promise
to
that's
operate?
my second topic. I
Right,
just
I
want
see.
to make some points on the statute.
Yes, I mean,
I'm sorry, so the proposition is that because the policy says you review in a week, it is precisely the same. There is simply no distinction at all between that and the case of Roberts that we looked at where the statute says.
That's what I'm coming to, but that is my submission.
I see.
The Secretary of State does not take issue with the Nadaraja principle articulated by Lord Phillips, that it is an established public law principle that you must act compatibly with the Secretary of State's published policy. Nadaraja is particularly cogent for our purposes for these reasons. Firstly, it concerned immigration detention under our statute.
Concerns
Immigration detention under the 1971 Act. Secondly, because it concerned the manual. When Lord Phillips is talking about the published policy, he's talking about the manual.
Could you give us the paragraph number in Nadaraja that states that principle?
Yes, my lady, it's
875.
It's right.
Bundle 8, and it's tab 75.
And you quoted the paragraph somewhere in your case.
And it's paragraph 54.
54
that we've quoted.
Our domestic law comprehends both the provisions of Schedule 2 and the Secretary of State's published policy.
Which under principles of public law he's obliged to follow. And we've cited in our case, and they are in the bundles, a
So it
line.
was irrelevant that actually there it caused somebody to be detained who otherwise wouldn't have been.
Well,
I mean, but
I'm coming to-
I do want to understand the width of the proposition. You
I'm
may be
coming-
right, but was that irrelevant?
I'm perfectly happy to deal with it now. As to whether Nadaraja required the person detained to show that they wouldn't otherwise have been detained, no, it didn't require that, and I contest that proposition in this way. Nadaraja says you have to follow the requirements of your published policy. That's what you have to do. And Mr. Tam accepts that in relation to matters of substance. So if it's the detention criteria in the manual, they might as well be in the statute.
I'm sorry, I lost the sentence.
Mr. Tam accepts that as a matter of substance.
Yeah.
If it's the substantive criteria on which you will detain someone for immigration purposes, and if you act incompatibly with the stated policy, that's unlawful, it's false imprisonment, and that's what Nadaraja decides, and that's accepted. And it might as well be in the statute. That's my submission. It's no different. Let us assume that what the Secretary of State does is to say, here is my published policy, there are 4 criteria on which I will detain you, Dr. Sadi. And then when Dr. Sadi appears faithfully reporting as required, the Secretary of State says, well, in fact, there's a 5th criterion. Wasn't in my published policy, but I'm going to detain you because you don't meet that 5th criterion.
And this was a policy that was specifically directed to detention.
Yes. I just
Wasn't it?
assume, but I'm just testing the
Yes.
proposition. Now, you could say, what should the Secretary of State have done? Well, what should the Secretary of State have done is promulgate a policy that had all 5.
Sorry, I had
All five
All five.
criteria.
yeah.
It's not a fanciful example. If you look at the case of Khan in the 1980s, where the family was told, if you meet these criteria, you can bring in this child from Pakistan. And then the Secretary of State says, well, actually, no, I'm going to apply a different criterion, and you can't. And the Court of Appeal says that's unlawful. And that was the beginnings of our doctrine of substantive legitimate expectation. But just follow through my example. Here is the 5th criterion. What should have happened is I should have promulgated a policy in which I stated openly all 5 of those criteria. Does that mean the claimant loses? Because had that happened, they wouldn't have been able to meet that test. My submission to you is that there is nothing in Nadaraja that requires that exercise in but for what would have happened. And even if there were anything in Nadaraja that suggested that that was the proper approach, it is one that ought not to be adopted.
Well, can we just look and see if it is? I mean,
Yes.
I'm sure you'll help us. I had understood that it was regarded as relevant, but you must just show us if you say it wasn't.
The Secretary of State's policy is set out in Nadaraja, and it's based on whether removal is imminent.
We have that quoted in the case, do we?
You'll see it in Nadaraja itself, for example,
paragraph
at paragraph 56.
26, we've got bits of the policy set out, paragraph 26, I think. It's factors influencing the decision to detain and so on, 6 factors. And then in paragraph 55, the policy is examined, and the particular factors which are in play are set out there. And the point
Paragraph
really-
56,
Yes.
it refers to whether your removal from the United Kingdom is imminent.
That's right.
And what had happened in Nadaraja was that there was an intention to challenge,
Yes.
which would have meant suspension and therefore non-imminence. Behind the scenes, the Secretary of State was applying a different criterion, namely, had an application been lodged? But that wasn't known about, it hadn't been published, and that's why at 66 and 67, Lord Phillips says you can't rely on that additional criterion. 67, it wasn't accessible.
That's particularly,
Now-
that's picked up at paragraph 68, actually.
Yes, now 68 is the ruling in the case.
Yes.
You met the criterion, the ones that have been published, it wasn't imminent, therefore you couldn't be detained. The only basis on which you could have been is something that hadn't been made public and the Secretary of State can't rely on it. That's the nub of Nadaraja. For these reasons, 69, we conclude that it was unlawful. And Mr. Tam has to then elevate an observation from later on in that paragraph that says, unlike the Khan family, you couldn't have met the additional criterion for bringing in the child.
Where does he say this?
It's 69, 4 or 5 lines from the bottom. Had she been aware of the unpublished aspect, they could have instituted proceedings. In other words, if we'd known, if you had had a published policy, that we're required to have triggered this non-imminence by issuing proceedings, that is what we would have done. N suffered because they couldn't foresee the consequences. Well, no doubt all of that is right. But it doesn't defeat the principle that what the Secretary of State has to do is comply with the stated published policy. I'm not going to turn up Khan, I haven't got the time. I'll give you the reference. It's Bundle 5, tab 41. Classic example where they couldn't meet the additional criteria. And that was the whole point of the unfairness of it being relied on.
Well, I think I've already made the point that it strikes me that Nadaraja was dealing with a policy that was particularly directed to detention and the circumstances in which detention would be continued. And what I'm interested in is how you can bring that approach into play in this case when we look at the paragraphs in the manual which
Absolutely.
you're interested in.
I promise I'm turning to that as soon as I can. Just to finish on the statute, though, that the procedure which is prescribed in immigration policy must also be followed as a matter of law. And that's been very well established for a very long time. I'll give you one authority. It's the case of Ng Yuan Shiu. It's Bundle 5, and it's tab 37.
You want us to look at that?
No, I'll just tell you that what you'll find, because you'll only need to read the head note to get it, is the Secretary of State was not entitled to remove someone, having said in a circular, in a policy, I will hear people's cases on their individual facts. There's a procedural requirement of an announced government policy. The Privy Council says you have to follow it. And it would be very odd indeed if the substantive criteria of a published policy had to be followed, see Nadaraja, but the procedural requirements of a published policy didn't have to be followed. Not least because you don't need to look beyond Article 5.1 to see that detention is unlawful if a procedure prescribed by law has not been followed.
Well, I mean, I absolutely understand that in the context of Article 5.1, but I thought you were addressing at the moment common law on...
I'm addressing the statute and the way public law operates in the context of the Immigration Act. So, procedural obligations equally, arising from a published policy equally. And so, if you were doing a constitutional consideration, and again, I dare not turn it up, I'll simply remind you where it is. Cooper and Wandsworth is Bundle 3, tab 24. The demolition of the house, without hearing what the builder had to say, Lord Chief Justice Earl, at page 417, explains that that obligation of procedural fairness was a qualification on the statutory power.
Well, I don't find that too difficult a proposition to understand, but I'd like you to move on, if you wouldn't mind, to what we're really dealing with in this case.
I understand. My second topic, then, is our submissions in relation to the policy, the manual. And what we say is this. If you look at the substance and the content, there is a striking parallel between the arrangements here for the immigration detention and the arrangements under the Police and Criminal Evidence Act for detention in the police station. You saw from Roberts there were really three ingredients under that regime. The first was that the statute explicitly acknowledged the significance of compliance, and I recognise that, and that was very important in that case. That was the first feature. The significance of compliance for the valid exercise of the detention power. That's the first feature. The second feature is that there had been an initial decision, and we looked at it with the fine-tooth comb. It was Bundle 7, tab 57. You'll recall the second feature was that there had to be an initial authorisation by the custody officer. That was section 37, the bottom of 664. Now, I ask you to note that that initial authorisation was in open terms by reference to the statutory purpose. If you look at 664 at letter B, that authorisation says, detention authorised to obtain evidence by questioning. That had not happened 6 hours in. It was an open authorisation for the purposes of the statute. Thirdly, the third important feature, and this of course is section 40, is that you get the required detention reviews with a prescription as to who has to do them and when they have to be done, and this description that they are authorising the continued detention. That's what the statute said. My submission is that there is the clearest possible parallel between the substantive content of those arrangements and the substantive content of our arrangements. The first thing we see when we look in the manual is the explicit acknowledgement of the significance of compliance for the valid exercise of the detention power. And it was the bottom of page 287 in Appendix Part 1. In fact, it's even more explicit than the statute was in Roberts, because it says, to be lawful, detention must accord with this stated policy. The second feature is that we get, under the manual, an initial authorisation.
So do you say that that adds anything? Suppose it hadn't been there.
If it weren't there, I wouldn't need it.
No,
And I wouldn't need it because of the public law obligation to which I
it
have
doesn't
referred.
add anything at all.
On my submission, no. If I were wrong, and there weren't that underlying duty of compliance, then it would add, because it would explicitly recognise the link between compliance and the exercise of the detention power. The second feature is also present, which is that one has the initial authorisation expressed openly. You saw the document. It's expressed by reference to the statutory purpose This is the authority of the immigration officer or the Secretary of State. It's page 290. But the third feature
Sorry, just
Page 290.
of the manual
Yes.
is referring to the power to detain.
It's this last paragraph on the page.
Yes, if you look at the bottom of page 290, that's a good example. Detention must be authorised at senior caseworker level in the Criminal Casework Directorate. That's talking about the initial authorisation. Now, pausing there, suppose that were done by the wrong person. Suppose it were authorised below senior caseworker level. That would be a procedural breach of this published policy. Mr. Tam has to say it wouldn't make the detention unlawful. Of course it would.
Whatever the reason for it.
It is required. It's bold.
No, I
and
see that. I
underlined.
see that.
Yes.
I'm saying
Yes.
whatever the reason, if they were all down with flu at the time or whatever it was, that would they took the next best thing.
Absolutely.
And that.
Suppose there's no notice of intention to deport because somebody's got flu.
Yeah.
You can't detain.
So same here.
Absolutely. And the third feature, almost as if someone has read Roberts and designed arrangements which secure the rights of the individual with no less protection in the immigration detention centre as you'd get in a police station. You have the required detention reviews with the detailed prescription as to who has to do them and when they have to be done. And that, of course, is paragraph 38(8), which you've already seen. Now, it is very clear that the requirement of this scheme is that in addition to the initial piece of paper, the initial authorisation by the immigration officer, continued detention must be authorised. And it tells us by whom and it tells us at what stage, and it's page 303. And for good measure, if clarification were needed, it describes the initial decision as having authorised the initial detention. That's the phrase under 38(8 at page 303. So what we say about that is that, yes, Mr. Tam can point to a document which is the immigration officer giving the open authorisation for the detention pending the deportation, or the Secretary of State if it's Schedule 3. In the same way that the police could point to an authorisation that said, I authorise detention for questioning once this person wakes up. But all of that is subject to the system of mandatory arrangements which follows.
Is one permitted to ask oneself what the purpose of these reviews is?
Yes, and it's clear on the face of them. They are authorising the continued detention. That's what they're doing. That's what's expressed. See 6 lines from the bottom on page 303.
And why should they be doing that? I mean, you see, I've read your case. I've also read the very interesting statement by Pierre Maclouf. And there's a good deal of emphasis in his statement on the vulnerability of detainees. And one understands that. Mental problems, family problems, and everything else. These people who may not be able to speak English, they need access to advice which isn't available, and so on and so forth. I can understand all of that. But, and you may be able to say that the reviews, or Mr. Tam may say the reviews are directed to that kind of thing, as it were, sort of pastoral care is understating it, but it's that kind of thing to make sure that people are properly cared for and looked after and in the right place and so on and so forth. But you're having to go to the length of saying that these reviews are essential to the continued detention,
yes, even
although there's an underlying reason for the detention which you can detect without looking at the
Well, that's what you've got to find out. But what you can't do is default on conducting the review. Certainly the reason why it's required, same as in Roberts, is to consider all the circumstances and to decide whether or not continued detention should be authorised.
And Mr. Tam also said, I'm just testing this point with you, if I may, he says, well, what you found in the manual is a statement of policy. Policy can change. And
one of the questions I'm going to come to at the very end, whether
right.
it could. But certainly. But at the moment, all I'm asking you to do is hold them to the arrangements that we have.
Right.
And supposing that the House of Lords had interpreted the section about the authorisation and had said, well, actually the scheme is that it runs until the person is deported, unless there are good reasons before that for the person to be no longer detained. Now, supposing that had been the view which had been laid down by the House of Lords as a construction of thing, would the regulations in here make any difference to the legal position? So it would change it, would it?
Yes, it would.
From being a review in order to decide whether or not to release, that would then become a review which was necessary in order to maintain the authority.
Yes, so test it this way. I mean, suppose there'd been a House of Lords case in 1975. Now then, there's no review on the face of the statute. So the House of Lords construes the statute, and it says as a matter of interpretation, this is what is required. Suppose in 1980, there is a promulgation of a policy guidance which states criteria for detention. Would that affect what the House of Lords had said? Yes, it would.
Well, that's the proposition. I mean, Cardier must have been wrongly decided.
No, I don't accept that's a necessary part of it at all.
Why is that?
Cardier is simply recognising that for the purposes of the power to give temporary admission, the power of detention is extant throughout. But Cardier says in terms that if, for example, it is unreasonable for detention to be imposed on an individual, then although you've got the power, its exercise is unlawful. And so Cardier...
You don't have the power after week one unless you've had a proper review.
Yeah,
well, the power exists in the Cardier sense. It cannot be lawfully exercised in the same sense as in Cardier. If that were wrong, there are problems on both sides of the court, because Mr. Tam accepts that you could not maintain detention incompatibly with Hardy-Singh principles. He accepts that you cannot maintain detention incompatibly with the substantive content of your published policy. None of that conflicts with Cardier. The only question is whether it matters that a requirement of the policy is procedural rather than substantive. Our answer is no, it doesn't, in principle. And secondly, what matters is, are you satisfied that a condition of the published policy goes to the power to detain? One needs that nexus. But in principle, there plainly is that nexus from arrangements of this kind. Otherwise, there wouldn't have been that nexus in Roberts.
Now, can I be quite clear where you're going? I think you said at the beginning you had 3 points to make in addition to the written case. How are we progressing?
Well, I'm on my second topic, and I'm well into it. Can I simply illustrate the point with one reference and one practical example?
Yes.
The reference is to remind you of the ministerial authorisation that is needed in the context of children. It's the top of page 309, and it could not be clearer. Weekly authorisation to continue detention.
Yes.
That means what it says. Albeit that an immigration officer has issued the same sort of document that was issued in Roberts, detain pending deportation. That's the beginning. That is necessary under the statute. It's not the end. It is not sufficient. Because if you're going to continue detention, you need a weekly authorisation. Now the practical test for that is this. You'll recall the document we saw yesterday. It was in the appendix and it was page 415 and it said authority for detention. Let us assume that the review has taken place as required. And you've seen the review documents. But let's assume instead of what we find, for example, at the foot of page 861, authority to maintain detention given, let's assume it's refused.
Assume what?
Assume the necessary authorisation for the continued detention is refused. And assume for the sake of argument it's refused by the minister, because it's a vulnerable child. The question which tests all of this is, does page 415 justify keeping the child in detention? This says to the constable at the gate of the detention centre, detain until the deportation order is made. Our answer is, of course it doesn't, because the law for the purposes of this detention power extends to the important protections which go to the power to detain, which are set out in the published policy.
I mean, if this memorandum was worded differently and simply said you would have all these reviews as to whether to release, I mean, you could easily adapt the language to turn it into...
Well, I'll move on from my second topic in the interest of time and turn to that. That was going to be my final point.
All right.
I said I wanted to deal with two questions, and then I'll sit down. The first question I'd like to respond to, which was posed yesterday, is this. Isn't it odd and unsatisfactory that one counts back through the calendar to see when you were lawfully detained and when you were unlawfully detained in order to give a monetary award for those periods in which it was unlawful? Is that really an appropriate response? We would say, firstly, it is very unsatisfactory that one is doing that. One is in that position because of the default in the performance of the necessary requirements in the arrangements that have been made, all avoidable. But certainly it is the logic of the law that one looks back to see when the detention was authorised. If you had a case where there was a delay in there being a notice of an intention to deport, so for 7 days you were in detention before that was actually done, you'd have a count back of 7 days when the detention was unlawful. If you had a Christian Leginsky case, you hadn't been given the mandatory notification, well, for that period you're unlawfully detained, but once you are given it, you're not. That's what Christian Leginsky decides. The better way of looking at this, we suggest, is to consider the position at the time. And from the point of view of the position at the time, there is a principled choice. The alternatives are these. Either you review or you release. What you cannot do is to default and detain. The immigration detainee should be in no less protected position than the criminal suspect in the police station. The final question is my Lord Brown's question. Could the Secretary of State simply reformulate the policy instrument so as to exclude either the required reviews at all or the requirement that says they are necessary to authorise the continued detention? It would be an astonishing thing for the Secretary of State to do, not least because since 1991, in instructions which are mandatory under the statute, as you saw yesterday, not only have the required detention reviews been part of the system, but they have been on the basis that they are authorising the continued detention. Could the Secretary of State do it? No. the Secretary of State could not. Such safeguards, we would say, are necessary. They are reflected in the almost universally accepted standards. The British are in no better position in this context than the French were in relation to children born out of wedlock. And the principle, and it goes back to the very first question I think from yesterday, is in HL, it's in our case at paragraph 41(3). Now, it's no more necessary for you to decide this than it would be under the Police and Criminal Evidence Act if one were considering Parliament repealing those provisions in the light of Roberts, which they didn't do, or amending them in the context of human rights protections. But that is my answer.
I mean, have we the least idea around the world as to how often they review in these administrative detention under the 51F cases?
I haven't, but if we are able to supply that, we will. But we say on the same basis that these procedural protections are recognised in HL, and we've given you the quotation, they would be required here. Strasbourg, in particular, would be wholly unimpressed by a system which, in Europe, with only one other country, deleted these important safeguards, not least in circumstances where they'd been in the law for 20 years, and they were only removed because they were upheld and enforced by the courts. I would prefer to end by putting it in a positive rather than a negative way. We say the importance of these reviews has rightly been recognised as appropriate. They have properly been included in the Immigration Detention Centre as they are in the police station. And it's appropriate to leave the final characterisation to a single paragraph in the judgment of Mr. Justice Mungby. It's at page 151 and it's paragraph 68. And he, we submit, correctly characterises in that paragraph the characterisation of these reviews under this system prescribed by law of a procedure.
Integral to the scheme. Integral to the scheme, he says.
Yes, absolutely. One is looking. Does it go to the power to detain? Is it integral to the scheme of detention? We submit that his analysis that the principle you're not to be detained beyond a certain period without a review undertaken at regular intervals, they're fundamental to the propriety of the continuing detention. They are a necessary prerequisite to the continuing legality of the detention. We respectfully commend to the court that conclusion. We have beaten our time estimate, but I would like to thank the court. We know how easy it is for the court to say to an intervener written only, and we're very grateful for that on this occasion.
Nobody could suggest that the intervener's case had been understated, certainly before him. Well, 3/4 of an hour available.
Unless I can assist you further, I'm going to...
Yes, of course, please do. Yes.
Could I just ask one question,
Related
which was the issue of bail
Yes.
that came up yesterday. Do you support the submission that if it's not possible to detain, whether for a substantive or for a procedural reason, it's equally not possible to grant bail? That was Mr. Hussein's submission.
Our position is that there are conceptual and practical problems with bail. The conceptual problem is that it is not the function of the bail court to decide the legality of the detention. But my client's position, and you'll have seen from their name, that bail for immigration detainees ought to be as far-reaching and informed a decision as it could be. It ought to be accessible. At one time it was going to be mandatory that there be automatic bail for everyone. The conceptual difficulty is firstly that functional point, that it's not a function of the bail decision maker to decide the legality of the detention. Second conceptual problem is if the bail decision maker is releasing on conditions, that does conflict logically with the idea that the person has been found to have a legal entitlement to be at liberty, because the conditions themselves couldn't be lawful. The practical problems are perhaps more of a concern from the
Well,
point
I'm concerned with the conceptual problem, which bothers me quite a lot, because there are plenty of other contexts in which you are liable to be detained in certain circumstances, but you can be set free on condition that you do certain things.
Certainly.
And so, although it may be possible, there is the power to detain you, the circumstances in which you need to be detained don't exist.
Yes.
But one of the reasons that they don't exist is that you can be granted bail, which means that you can be required to turn up at police stations or do whatever it is that enables the authorities to keep you on a string. There are plenty of contexts when there is the liability to be detained, even though it is not either appropriate or necessary actually to detain you. That's the point I'm getting at.
I understand. I mean, my answer in the immigration context is simply that the justification for detention has to be the one substantively articulated by the law and in the policy guidance. So that answers the question of when can you and when can't you detain. I accept the proposition that the bail function would allow a decision maker in principle to say, well, those are met, but nevertheless I'm going to release, and I'm going to release on conditions. That would be consistent with what I've said about what the function of bail is. But of course, what matters is that it's not an either-or, and it was never an either-or. These mandatory detention reviews were alongside bail rights, even when automatic bail rights were being contemplated. And you don't need to look beyond the white paper of 1998 to see that the dual protections were being required. Bail is no more an answer to this case than it was an answer in Roberts under the Police and Criminal Evidence Act. There are major difficulties in any event with the practicalities of bail, and those are set out, I hope, helpfully for the court.
Well, I think they're covered quite well by your witness's observations in his statement.
The both and point is bundle 2, tab 13. It's paragraphs 12.8 and 12.10. And it emphasises that even when they were contemplating automatic bail hearings, the fundamental importance of the reviews of detention remained. Lady, I hope that's an answer to the question that you've asked.
It is an answer. Thank you.
Unless I can assist you.
Well, thank you, and may I also say how grateful we are for the clarity of your written case, for which no doubt your junior was also responsible. Thank you very much. Mr. Tarrant.
Please report. While I'm just setting up the practical arrangements,
Yes.
we have prepared a little almost agenda of the structure of the main part of my submissions. I wonder if it might be convenient for that to be distributed now.
Thank you.
No, I'll just start with one for the moment. No, leave. Just a sheet.
Thank you.
Before I actually embark on the main part of this, can I deal with, first of all, the preliminary matter of anonymity, which my learned friend Mr. Hussain mentioned at the outset yesterday. We would ask for the anonymity in this case to be maintained. As your lordships know, it's been a principle the practice of the Court of Appeal for some time, formalised in a practice direction, and adopted or to follow the practice in a number of other jurisdictions around the world, because of concerns in asylum cases about what might happen if an individual's, or the details of an individual's claim linked to that named individual were to become known to the authorities in the country of origin. This is probably not the best place to enter into wholesale review of the merits of that. But on the particular facts of this appellant's case, can I point to just a handful of features of his asylum claim which show that this is not by any means a fanciful suggestion in the context of his case. In Appendix 2, at page 558 is the first appeal decision of the AIT. Which sets out the claim that the appellant made in his asylum claim. Paragraph 9, for example, on page 559, referring to difficulties with the ruling party in Zimbabwe. And then over the page on 561, paragraphs 19, 21, 22, and 23, further allegations about what elements associated with ZANU had done to him. Now, of course, the appellant's claim, the asylum claim, has been found to be transparently fabricated. So none of this is true. However, this is the sort of party which might well take umbrage simply at the fact that the individual has said these things. And that might in itself cause some risk to him. Now, as I say, this is perhaps not the best time and place to enter into a lengthy debate about the merits of that, but that is certainly one of the bases on which asylum claims have been recognised. That is to say, you make a completely bogus claim for asylum, but the fact that you said what you have said then puts you at risk in the future, and you turn yourself into a genuine refugee but by that means. There was some argument about that in the mid-1990s about whether or not that was a valid basis on which to claim asylum, and it was held ultimately that it was, and one can certainly see the risk there. What we would ask the court to do in this case, given that that is the nature of what this appellant has actually said, and given the nature of the party in Zimbabwe of which we all know from news reports, this is not a case in which to summarily lift the anonymity. This could raise a real issue, and if a lengthy debate is needed about whether it is appropriate to continue the anonymity for this individual, or indeed a debate about the merits of the policy generally in relation to people who have made asylum claims, then perhaps we would need to...
I think we can probably leave it there, Mr. Tam. I think you've drawn attention to enough to make the point.
I'm very grateful.
Thank you.
Then turning to the case itself, it wouldn't be right for me to completely skate over the facts. We've said some things in paragraphs 5 and 6 of our printed case, but it is right that orally I should acknowledge to the court that we know that things went wrong in this appellant's case. And indeed, it is not an isolated incident, as the documents themselves show. And of course, as the court has seen in slightly different contexts in relation, or in the case of Abdi, for example, there have been other things that have gone wrong. And it is a picture which is unsatisfactory, as we recognise, and I should say that orally to the court. We accept, of course, that when things go wrong like this, it doesn't mean that the Secretary of State has not acted unlawfully in any way. Learned Friend's submissions, the burden of them has been to underline the many different ways in which the events that have happened might be unlawful, because they are in breach of public law principles. The Secretary of State should have done this, should have done that, and he hasn't. And there are legal principles that govern what he should do. none of that is in dispute. It is very likely, indeed almost certain, that a number of public law principles have been violated in the circumstances of this case, and that some legal remedies would undoubtedly follow for the appellant as a result of that. And
Like
you
what?
might,
What's the remedy?
well, the immediate response to a failure to carry out a detention review. For example, if you're in a detention centre and you know you have a statutory right to expect reasons every month, and they don't come, you'd say, where are the reasons? Have you done a review? If you haven't done a review, I'm going to judicially review you to get a mandatory order to order you to review my detention and decide whether or not I should now be released. So undoubtedly, that is the sort of thing which the appellant could have done. And in that sort of context, one might readily say, of course, the Secretary of State has acted unlawfully, or he has failed to act, and that failure has been unlawful. But that, with respect, is not what this case is about. This case is about a very specific question, which is, in these events, is the appellant entitled to claim damages for false imprisonment? Almost entirely, that is the way in which the appellant puts his case. It's almost an all-or-nothing thing. The suggestion that there might be Human Rights Act damages under Article 5 is almost tucked in as an afterthought, and the reason for that is obvious, because there's a causation requirement, and he has causation problems. So really, this is pretty much an all-or-nothing case for false imprisonment. That is what this case is about, and that, we say, is that what the appellant simply cannot establish in the events that have happened here. Lords, what I propose to do, therefore, is to examine under the various headings, the way in which the appellant might be able to establish the tort of false imprisonment, and demonstrate that actually he doesn't get home on any of these.
I mean, there is the Article 5. You've got to deal with Article 5 too. I mean, that's one of the stated issues.
I will, and that's why Article 5 is, in fact, sort of item D on the agenda. Yeah. And I will come to that at the end.
I see.
Yes. Fundamentally, we say it actually makes no difference, because on the way that the case is put, we're either going to lose on the domestic law and be in breach of Article 5 at the same time, or if there's no unlawfulness under domestic law, there's nothing extra in Article 5.1 that he can pray in aid. But I'll come to that, if I may, at the end. False imprisonment, of course, is a tort that fundamentally comprises detention without lawful authority. And we know that it's for the detainer to show the lawful authority for the action that he's taken to detain the individual. There are two fundamental themes of the appellant's argument. The first one is, whichever route the appellant was going down, it always comes back to the proposition that the detention was only lawfully authorised one chunk at a time. That there's no way round that. However, the analysis was put by my learned friend Mr. Hussain, that was really the fundamental point of his case. And what we will show is that actually there is no route through any of the materials to reach that conclusion.
Only lawfully authorised, what did you say?
One chunk at a time.
Chunk, I'm sorry, one chunk.
Every 24 hours to begin with, 7 days, 7 days, 7 days, and so on and so forth.
That's right. And we say that if you look at all the materials, there is just no basis for coming to that.
I mean, that's position under pace, but not here. That's what your
Exactly.
proposition.
Exactly. The second underlying point that we want to make is that much of the appellant's submission fails to recognise that the error here is actually one of omission and not of positive action. Now, somebody might say, well, that's a bit technical, but it does matter, because if somebody makes a positive decision to detain, it's quite easy to say, well, you've done this wrong, and you've done this wrong, you've done this wrong, and then the decision itself becomes unlawful, it has no effect, and the detention becomes unlawful. And we'll see when we come to cases in which that has happened. But what is actually happening here is that there's been an omission to consider whether the individual should now be released.
With the result that the individual remains locked up.
That is a result, yes, I accept that. But that is important when you ask yourself, well, what are the consequences of the occurrence of the omission, and what should the legal remedies be for that omission?
And is the exercise any different in this context then from PACE, if you have an omission in the PACE context?
Oh, it is different here from the PACE context, because one of the things you have to look at is, what does a statutory authority say? What is the statutory backing for it? What is the statutory context? In PACE, as Robert says, the detention is only lawfully authorised one chunk at a time. And that's the fundamental part of the Roberts decision. Whereas here, we have a completely different statutory scheme. The statute is quite explicit about the duration of the existence of the power. We have case law that explains how long you can exercise that power for. It does not say that whatever you do with reviews, that the review is only authorising one chunk at a time. This is a very different scheme, and that is why we say that there is simply no way that you can get through the materials to reach that conclusion.
I mean, one suspects that when this Act came in, 71, you were thinking of really comparatively very short times up to the deportation order, and then once it'd been made until you ship the chap out. And I doubt that there was any review process instigated at that time, because it probably wasn't necessary.
We've tried to find out, and we haven't been able to get a definitive answer to that question.
Now you deal with it in years, and I mean, I'm very far from sure Parliament, would today have just given an absolutely unlimited detention power stretching over years, which is what you say you've got.
Yet, in this case, it's not disputed that the Hardale Singh principles were observed, as I understand it.
That's correct, because Mr. Justice Munby found that they had been observed, the Hardale Singh limits had not been exceeded, and there was no appeal from that in the event, and that is the basis on which this case is before the court. The first 2 points that we make, in fact, A1 and A2, are that the statute gives a power to detain, which is limited, expressly limited, only by the occurrence of the pending event. But on top of that, there is now the implied limitation through Hardale Singh that you can only exercise it up to a certain point, and then the exercise must cease and the individual must be released. And clearly, SK is within those parameters, and there's nothing wrong with those.
Yes.
So can I then turn, first of all, to look in a little bit more detail at the statutory provisions, and then to respond to some of the points that learned friends have been making. I don't know if the court now has the core volume, or whether it's a different version to use, but can I look at the Immigration Act itself?
Yes.
Wherever you're working.
I think my core bundle is upstairs, isn't it? Yes, I'm afraid Eddie Hale and I are not using the core bundle. We're looking at...
Authorities 1, tab 1 as well.
Yes, I think I've got the pages wrong.
Well, it's tab 2.
Tab 2, I'm sorry.
I suppose you could
I should have torn it out.
The actual detention, or the deportation power and the detention powers you've seen already, so in the interest of time, I don't think I'll go back to them. The only reminder that I would like to make is that in the case of Kadir, as Lord Brown points out, that the decision was that pending simply means until, and so that gives you the end stop of that. But in order to understand a bit more about how the Act works and how that translates into practice, can I ask to go, please, to Section 4 of the Act.
Yes. Administration?
Administration of control.
Yeah.
Section 4.1 is quite an important provision for some of for the purposes of the paragraph 1.3 of Schedule 2 submission about instructions to immigration officers. The power to give or refuse leave to enter shall be exercised by immigration officers, and the power to give leave to remain or to vary any leave shall be exercised by the Secretary of State. So right from the inception of the Act, there was a distinction drawn between what are sometimes called on-entry cases and after-entry cases. On-entry cases dealt with by the immigration officers who were historically part of the immigration service, and after-entry by the Secretary of State via normal Home Office officials, let's say acting under Carltona principles, within the Home Office, IND, and now through various names into UK Border Agency. And of course, the Secretary of State is also responsible for deportation, as the court saw in Section 3 and Section 5 yesterday. There is a distinction there. Immigration officers have to be warranted. They carry warrants as immigration officers, and there are certain things in the statute that only immigration officers can do. That may be important where you are dealing with a function which is to be exercised by immigration officers. Over the last few years, there have been a number of statutory changes that have blurred the line, or rather rendered less important that distinction in certain places. But immigration officers are a specific statutory creature, and there are certain things that only they can do. The point is, of course, that none of this is really important here, because we are dealing with deportation and detention under deportation powers, and this is all done by the Secretary of State. And as a matter of practice, it may or may not be done by a warranted immigration officer. Indeed, the vast majority of decisions relating to deportation and detention under deportation powers is done by officials who are not immigration officers. They are civil servants, and they are Home Office civil servants who work under the Carltona principle. And that is why, if you look at the policy, for example, if you go to page 287, so the 287 is where the OEM Chapter 38 starts.
Sorry, this is 287 in the appendix.
It's in the appendix, sorry, appendix part 1.
Yeah.
Perhaps a place to point this out from is page 296.
Yeah.
It's just to illustrate this. On 296, paragraph 38.5.1, legal entrant can be detained on the authority of a CIO, that's Chief Immigration Officer, or a higher executive officer. And those are the warranted and non-warranted grades that are equivalent to each other. Immigration service on one side, and non-warranted Home Office official within UKBA. And similarly, if you go down to the bottom of the page in the special cases, you see the correspondence between inspector within the immigration service and senior executive officer or assistant director outside the immigration service, women's CIO, HEO, and so on. And so the powers with which we are concerned here are powers that are actually exercisable by non-immigration officers as well as immigration officers. And that is why, if I can dispose of the point now, the argument that there is a specific statutory duty via the instructions to immigration officers provision in paragraph 1.3 of Schedule 2 doesn't work, because if and to the extent that any of these decisions is made by an immigration officer, it's actually being made by an immigration officer just acting as an ordinary civil servant under the Carltona principles. And
Well,
as often
Mr.
as...
Fordham, I think, dealt with that earlier today, saying that the Secretary of State, in effect, is doing this, and he's bound by his own published policy.
Oh, yes, I accept that. But the point is, as the Secretary of State doing it, and instructions to immigration officers is not relevant for these purposes. Because if and to the extent that an immigration officer does this, and I understand it's relatively rare, they are simply acting as a Home Office official.
I mean, what's really complained of is actually not that they're not doing it. And so you ask whose failure it is, and then you would say, well, the failure is that of the Home Office.
Yeah. Well, that's right. But the argument about instructions to immigration officers has no separate life, and that's the point I want to make. Now, having looked at that, can I ask to go, please, to the case of Roberts, which is the Pace case, and just to show the court some of the distinctions between them. Sorry, volume 7, tab 57. The point I'd like to make here is really to respond to my own friend Mr. Hussain, who said that this was all about reviews generically and nothing specifically to do with the statute. What I hope to show the court is that actually Roberts was all about the statute. And without the specific statutory language and structure, the case might not have been decided the same way. On page 664, at letter G, there is the first part of the quoted provisions of the case. 34.1, a person arrested for an offence shall not be kept in police detention except in accordance with the provisions of this part of this Act. So,
Where have you just read that?
Oh, it's letter G on page 664.
G, I'm sorry, yes.
And then, in the following parts, provisions of that part, there are the custody officer provisions, and then over the page 665, letter B, section 40, reviews of the detention shall be carried out periodically in accordance with the following provisions of this section. And then at letter D, you've got the timetable there set out. So the clearest possible statutory language that says you can't detain unless you comply with all of these provisions. And therefore, it's no surprise to see at the bottom of page 665, the last paragraph, Lord Justice Clark saying section 34.1 of the Act is mandatory. As already stated, it provides that a person shall not be kept in police detention except in accordance with the relevant provisions of the Act. Then gives the times, and it follows, as I see it, that from that time, that's 5:25, when the first review was missed, that from that time the plaintiff was not being detained in accordance with the relevant provisions of the Act. It further follows that his detention was thereafter unlawful until some event occurred to make it lawful. Attention, I think, has already been drawn to the passage at 667 between letters B and C, rejecting the causation argument there. So we respectfully say it's crystal clear that Roberts is all about the statute, it's all about the language used in 34.1 and the strict timetable laid out in 40. And that is what the decision depended on. And if you contrast that with what you find in the 1971 Act, there are no provisions in the Act for reviews. I've already identified that it's limited expressly only by the event that is to come, and then impliedly by Hardiel Singh. But there are no provisions in the Act for reviews. There are no statutory preconditions other than paragraph 2.2 and 2.3 requirements that start the power of detention, and then the events that terminate the power. And Hardiel Singh itself recognised that the statutory language provided no limitation on the time for which the person could be detained. Can I just ask just to turn that up? It's tab 5, volume 5 at tab 40. And it's 706 at letter D. Just above letter D, Mr.
Sorry,
Justice
page.
Ward-
I'm sorry, I've got the tab 40, I'm so sorry.
Tab 40.
Page number?
706, letter D, or just above letter D, where Mr. Justice Wolfe identifies that the applicant's been detained under paragraph 2.3. Although the power which is given to the Secretary of State in paragraph 2 to detain individuals is not subject to any express limitation of time, I'm quite satisfied that it is subject to limitations, and then he sets out those implied limitations there. So that is that's the statute. These limitations in Hardiel Singh, sorry, moving on to A2, have been explained in various cases that have followed. Can I just give you the references to save time?
Didn't we collect them all together in Kadir?
Yes, they are collected, and they've been successively collected together in the cases. But the cases are Hardiel Singh itself, Mahmoud, volume 6, tab 49, Tanti Lam, volume 6 at 54, volume 6, tab 54. The case of I, in volume 8, tab 69, where at paragraph 46, Lord Justice Dyson usefully distilled them into the 4 principles, which is perhaps the most useful place to find them, and of course they are mentioned in Kadir. So, that being what is established as being the law, we go on to ask then, well, where can one find any provision or rule that limits in any other way the validity of the Secretary of State's authority to detain? You don't find it in the statute, you don't find it buried anywhere, you don't find it in the rules, and you don't find it in the policy. So can I deal with those 4 in turn? First of all, there are no limitations to be found in the statute, as I've just said. The documents that are used reflect the statutory language, and you have seen some of them. Can I ask to draw attention just to a few more surrounding the decision to detain, so that you get a picture of how that is done? It's in Appendix 2. And can I start at page 391, please? 391.
Sorry, we're looking at Appendix 1.
Appendix 2.
Appendix 2.
Please.
Page
391.
Page 3.
This is a minute of the decision to detain, and it sets out some details of the appellant's case and consideration under various headings of whether or not he should be detained. And then over on 392, there's the proposal that he should remain in detention until deportation, question mark, agree. And then there are 2 boxes at the bottom for IS 91 prepared and detention authority prepared. So those 2 documents go hand in hand. Likely that either one would be sufficient, but clearly both have been done. On page 396, it's a document that you haven't seen before. which is the notice of intention to deport, which of course is the starting point that triggers the existence of the power to detain. That is accompanied by the reasons letter, which you'll find at 401, going to 402. And then you have the IS 91, starting at page 408. And you see that it's addressed to the custodian, and this is to authorise the detention of, and then it gives the appellant's details, and it's signed at the bottom of that page. Just observe that on pages 409 and 410, there are a number of matters which might be described as administrative, including on page 410, the transfer record, and then also there's a reference to accounting matters near the bottom of that page. I'll show you the reference in the to that in the policy when I come back to it.
So where does it say how long you can be detained for?
Well, this one doesn't on its face.
No.
However, what is on page 415 certainly does do that. And that's why I showed you how the decision-making process and the generation of these documents produce these two documents hand in hand.
So is the authority, at page 415, the document that's referred to in a little box at page 392?
Yes, it is, yes.
That's 415.
The IS 91 goes to the detainer and the detention authority goes to the detainee.
Well, it's addressed to the detainee, but of course the authorisation having been recorded there, this document clearly has effect to authorise the detention, and this one does set out how long the authority is expressed to last for.
Where do we find that? That's the bottom paragraph. Is it until deportation order is made or an appeal is determined in his favour?
That's right, yes. So and that reflects the statutory language, which allows detention at this stage pending the making of the deportation order.
So is this meant to be given, I mean, is the idea that this authority for detention is given to the person who's to be detained in order to show under what power he's been doing? What's the purpose of it? It's addressed to him.
It is addressed to him, and it would certainly show him that authority has been given for detention.
I mean, there's a slightly odd letter on page 411 which begins, "Dear Mr. Kambadzi," and then it says, "About him, and as you are aware, deportation action is being pursued against the above-named prisoner. I shall be grateful you pass on the following information to him."
Yes, please give him.
The dangers, I suspect, of copy and paste and the use of standard templates.
This presumably, who is this meant to be addressed to? Presumably it's the prison authorities or something.
Yes, there will have been documents addressed to the prison authorities. So if you go back, for example, to page...
And this is before he's released from a perfectly conventional prison sentence.
That's right. And the following day is addressed to Wood Hill. Is that the detention place?
Well, that's the prison where he was serving
That's where he was
Oh, sorry,
serving
beg your
his
pardon.
sentence.
Yes, of course it is.
Yep.
And then he continued to be detained there
Yes.
for the first period of his immigration detention.
Yeah.
If you go back to 406, you'll see what's actually was practically done, which was to serve a number of documents it's a request to the prison to serve a number of documents on the appellant, including the IS 91, which we've seen, and the ICD 0257, which is page 415. You see the number in the bottom left-hand corner.
It is a formal document given to the governor of the prison authorising his indefinite detention.
Well, the IS 91 is certainly given to the prison governor because that is required, and it's addressed to the custodian, and it is required to be passed from one to the next.
But it doesn't say how long he's to be there, is it? Or is it? Or maybe it should have.
No, I can't see that expressly stated here.
Does it have...
But of course, that doesn't necessarily matter, because the authority itself doesn't have to be given in writing. What we're seeing here is documents recording the authority which was given, and the clearest statement of that is on 415 in the document that is addressed to the individual.
So what happens to the 415? That's addressed to him.
It is addressed to him.
Does a copy go to the detainee?
We will ask what the practice was, but you see on 411 that the letter does ask for a copy of the ICD 0257
Yes.
to be given to him. So it may well be that there is a copy kept by the prison
The
as well.
enclosed copy.
Yes. And
One assumes there is a file that travels with the prisoner, which would contain these documents.
yes, well, it should certainly contain the IS-91, because that expressly says it must go from place to place.
So what is the IS-91?
IS-91 is the document on page 4.
Yes, I know that, but what is it?
Well, it is also a detention authority. It is described as that in its heading. That's...
Well, they seem to have generated more than enough documents.
and it is addressed to the custodian. This is to authorise the detention of.
Minister in charge of documents. Well.
Yes.
Yes.
I didn't know how long for.
No doubt if one was trying to be green and efficient, one could reduce the number of pieces of paper that are generated. But if you look at the documents which were, it's quite clear that the authority that was given reflected the statutory language and were intended to have the same effect as the statute's permission.
Could you help me looking at page 416? There's a reference there to the attached RFDL to be served immediately on the above. Do you know what that is?
Yes, that would be either reasons for decision letter or possibly reasons for detention letter.
Yes.
And
Yes.
there was
That was 401.
a reasons letter. Well, there are two reasons letters. One relates to the decision to deport him, which is 401. But that should have been served at the earlier time. There's then a reasons letter relating to his detention, which is on 413.
Yes, I see.
But that is dated the 8th of March, and
Yes.
I'm afraid I don't immediately know why there was a further request on the 11th of March to serve a copy of that letter.
This is all still addressed to Wood Hill.
It is, and the appellant remained at Wood Hill for
Until
quite
April.
a number of months.
Yes, until April, I think you
Yes.
said. Was it?
To April 2007.
That's right, yes.
So it was about 13 months or so.
And it was only when he moved that you say that he became subject to Rule 9.1.
Indeed, yes. Yes. So Rule 9 simply had no application.
No, it didn't
to him.
apply to the prison. Yep, thank you.
The other document that authorised detention and reflected the statutory language was the deportation order itself, which is at 784. And for our purposes, the relevant paragraph is the third paragraph, now citing paragraph 2.3, which is the detention power which comes into existence on the signing of the deportation order. The Secretary of State hereby, using that word again, hereby authorises the appellant to be detained until he is removed from the UK. So if you're trying to find...
Just to complete that, if you look at 785, the box second from the bottom, please see attached detention review and deportation order to be served on subject. So this is, for obvious reasons, is served on him.
Yes. And we apprehend that the detention review will be that on 782, 783.
Yes.
So, on their face, we say that you can't find any other limiting provision or rule, either in the statute or in the documents which were generated, that actually exercise the power to detain. The second point is that there isn't anything hidden in these documents either that are inconsistent with what they say on their face. We've seen what they say on their face, and they do authorise detention up until the limiting points. The way that we approach this is to ask the court to imagine someone who's making a traditional habeas corpus application, and that's traditional in the sense of not even under the modern practice, which, as Lord Brown has pointed out, doesn't actually result in the issue of the writ at all, but the traditional way where the writ would issue and the jailer would present the prisoner and the authority for detention. And you ask yourself, well, what would the jailer, what would the governor of Wood Hill Prison do? He would provide either the IS-91 or the ICDO 257. If he only provided the IS-91, no doubt somebody would say, well, this doesn't say how long it is, and there'd have to be further evidence that shows that actually the detention authority was until the making of the deportation order. But if you look at those documents, that is what the governor has authority to do. Those documents ought to mean what they say on their face. Now, my learned friend, Mr. Hussain, suggested that this was some sort of forensic trick because the prison governor, if he produced this, would be as liable as the Secretary of State for the detention if the Secretary of State had made some error that vitiated the detention authority.
That's the Evans point.
That is the way he characterises it. But can I show you a passage in Dunn which suggests that that is not correct? Dunn is the parole board case. It's in volume 12 at tab 103. And the relevant passage is in paragraph 29. Now,
79.
29. It's
29.
on 29 on page 742. Now, you'll recall that Dunn was a case in which the parole board was seized of the individual's case, but had delayed in producing the result, and that was held to be unlawful. But at 29, what Lord Justice Thomas said was, under the statutory regime, even if there were unlawful detention by reason of the magnitude of the delay, would the consequence wouldn't be that the claim lay against the parole board for false imprisonment. The detention was by the prison governor acting on the authority of the Secretary of State. The claim for false imprisonment would lie against the Secretary of State and not the parole board. So we say it must be at least open to some question whether
Sorry, what are you saying? I mean, if somebody was held under this warrant beyond the Hardial Singh limits, and you issued habeas against the governor who was detaining him, I mean, that would be an unanswerable claim. Right?
well, under the current practice, that this issue wouldn't arise, because what would happen is the Secretary of State would come and say, well, this is my authority to detain, and I say that it hasn't breached Hardial Singh limits, and the judge decides it has, and an order goes for the individual's release, and the relationship between the individual, the governor, and the piece of paper is never actually explored.
Well, I've no doubt that's right, but I mean, only because it becomes of complete irrelevance to. He's going to get his money. He doesn't care if it's the governor who pays or the Secretary of State.
Well, indeed, but this is why I say this is not just a forensic trick. Admittedly, this is a procedure which doesn't get invoked today, but we respectfully say that it is a useful question to ask as to whether there is anything hidden in these documents which provides some limitation on the validity of the authority to detain.
Could you just look back at page 729, letter F in the holding, just to see if I've got this correct. 729, the holding at letter F, which I think is directed to this point. It's really a case, the point being made is you direct your claim against the Secretary of State, not the parole board. But I don't see where this takes us in this case. That's the point that's being made, as I understand.
Well, the point that I derive from this is that it doesn't seem to be suggested that the action would lie against the prison governor. It would lie against the person who's authorising the detention.
Or who's failed to carry out the reviews, the Secretary of State.
Yes, but that is right, and that is what the appellants seek to establish. But what I'm trying to look at here, when looking at the documents, what they mean and what effect they have, is to look at the position of the prison governor. Here he is, he's presented with an authority for detention. He's being told by the Secretary of State, detain this person until this event occurs. What is a prison governor to do? This is what his instruction is, and this is what he would be acting on.
What if somebody's granted bail and through some error the actual document doesn't reach the prison governor, and so the prison governor continues to detain this person when that's quite clearly unlawful? What's the situation then?
Well, the individual would be entitled to get an order that the prison governor release him, having been granted bail.
Of course.
But that doesn't itself answer the question of whether...
No, I'm asking you the question.
Yes. Well,
there obviously is a claim for false imprisonment. It's clearly false imprisonment to continue to detain somebody who's been granted bail.
Well, we respectfully say that depends on an analysis of of what has happened to the authority to detain, and we say that what you can't do. Sorry, that I'm perhaps getting too involved in the complexities of this. What I'm trying to do is to say that the one thing you can't do is to say, well, here you've got this piece of paper and it says detain this person until I make the deportation order. This is the Secretary of State's instruction. Detain him until I make the deportation order. And there's nothing in the statute or the rules or the policy that suggests that actually the prison governor must take this and read this as, please detain him until 24 hours' time, which is the burden of learned friend Mr. Hussein's submissions. It simply doesn't say that. And the only way that
this is quite common, that you might have a situation in which there is an apparently open-ended authority to detain, or not open-ended but ending at some point in the future, but then some event happens, or on this case doesn't happen,
yes.
Which actually brings that to an end earlier than
yes.
that. And it becomes unlawful then to detain
indeed.
the person.
And it all depends on the statutory context.
Well, we're back to whether it's in chunks or whether it isn't in chunks.
Indeed, and we say in this context there's nothing in the statutory context that suggests that this is in chunks, because the statute doesn't say so, the documents don't say so, and just looking at it as I'm trying to do hypothetically through the eyes of the prison governor, that the document doesn't say that to him. There are circumstances in which you do that, because in Roberts, for example, the statute says you detain in chunks. The statute says unless these provisions are complied with, then he may not be detained any further. So the prison governor, well, the custody sergeant in the police station, will be able to say, okay, I've got to let him go now because there's been no review, in theory.
Just before we put Dunaway, I mean, was that decided before Black in the House? Well, I'm just wondering, I don't think it matters from just from my own interest. I mean, it seems to be looking at a fairly historic view of it all under Johnson. I thought we overruled Johnson. But I mean, there it is, it doesn't matter to me. So I don't want to take time. If you don't know the answer, forget it.
We'll find that. So Roberts is one example of a statutory context in which the piece of paper, if there was a piece of paper, wouldn't mean what it said on its face. Evans is another example of a piece of paper that doesn't mean what it says on its face, because the warrant of the court is detain this person for 2 years, but the prison governor knows, because of sentence calculation statutes, that actually he's got to sit down and work out what it does mean. In Evans, of course, he was inadvertently in error because he worked it out according to what the law was then understood to be, which was incorrect.
I mean, your documents aren't right on their face insofar as they don't take account of the Hardy-Singh principles. You say that this is authority to detain until you finally get rid of him, but yes. Hardy-Singh says, well, sometimes you can't.
And Hardy-Singh is a principle which is well established.
Yes.
And
all
so
I'm pointing out is the document on its face, therefore, is subject to that qualification.
Indeed. But what Learned Friend needs to do is to get as far as saying, well, actually, this document doesn't mean what it says on its face. What it means is what's in the policy and in the provisions set out in the policy from time to time. And we ask this question, how would the jailer, how would the prison governor know that? Because in this context, review durations are set by policy. The timetable could be lawfully amended from time to time. I don't understand anything Learned Friend Mr. Fordham says to suggest that can't be done. And amendments of the timetable or different timetables for different cases are set. What about the levels of authority at which detention needs to be authorised? They could be changed from time to time. And the prison governor would fundamentally have to keep himself on top of every bit of policy and every change in the policy, and look at every detention review that came to him to work out whether or not this was still a lawful authority. And if something came to him and, say, a letter had been missed off, the C had fallen off in front of the IO, if it was a CIO authorising detention, would the governor have to say, oh, this is at the wrong level, I must now let this individual out because the detention has ceased? In a situation where there isn't even a requirement that detention reviews be sent to the prison governor, we say that this is a conclusion which the court should not reach. That is taking the Roberts, the Evans principle far too far, and there is nothing in the statutory setup that suggests that that is as far as it should be taken. The third place that you don't find any provisional rule limiting validity is the detention centre rules themselves. you've seen Rule 9, I won't turn that up again. We make these points. First of all, it would be odd if the construction of the statute and the way in which the statutory power was to be exercised was to be construed according to what the rules provided. But in any event, there are some other problems with this because the rules only apply to certain categories of immigration detainee, i.e. those in detention centres, and not to those who are in prison. And the appellant is an example of somebody who was under both regimes at different times. The language of the rule itself does not compel a review to be carried out. What it says is that the reasons have to be provided. Obviously, the contemplation was that it would go hand in hand with a review, but it would be odd for a review to be mandated by a rule which doesn't even say that one has to be carried out. So we say that there are a large number of problems with that particular route of trying to impose a limitation on the validity of the authority to detain.
The reasons must be contemporary, presumably. They must reflect the situation at the time.
They must, but experience shows that if somebody is waiting for a number of months for something to happen, for example, like an appeal that's been listed to come on for hearing, the reasons can well be the same from month to month. You're waiting for your hearing, it's coming up, it's coming closer. There would be no difficulty in the reasons being the same and properly being the same, even if there has accidentally been a failure to carry out a review in the interim. So the two are not necessarily joined together, although clearly that is contemplated.
Where are the rules again?
Page 266 in Appendix 1.
Yes.
266.
266. That's Rule 9.1, which I think is the only rule we need to look at. Is that right?
It's the only rule that we need to look at specifically. Although we do make the point in our printed case that if you look at the rest of the rules, they do have the flavour of the management of the detention centre rather than anything to do with detention itself. And they are, in that respect, very similar indeed to the prison rules, which were the subject of Hague. Hague is a case I'm going to have to come back to under Section C of my submissions, but can I just make this point about it? The attempt in Hague was to to make actionable a breach of the prison rules. And that was rejected on a number of counts, including the fact that there was no action for a breach of statutory duty because of the context in which the rules were made. That point applies to the detention centre rules. And secondly, trying to get the argument into false imprisonment was bad for a number of reasons, one of which was it was trying to get a breach of statutory duty action in through the back door. And that also applies equally to these to the detention centre rules.
Is it worth just glancing at page 286, which is the explanatory note? It's a fairly brief note, but the opening sentence does fit with what you've just said, regulation and management of detention centres.
Lord, yes. And we say that is an accurate description of them when one looks, for example, just at page 261 and goes through the list of matters that are dealt with.
I mean, they presuppose there's going to be a monthly review, and obviously, assuming that there is going to be a monthly review, well then, for the management of the prison and all the rest of it, it's obviously sensible that you tell the chap the result of it. Give him his reason.
Indeed.
Well, do you accept then that it is necessary to conduct a review in order to fulfil the duty in Rule 9.1?
I don't accept that it's necessary to conduct a review because the text of the rule does not actually require that. It may be that if no review is carried out, the reasons will either be meaningless or perhaps they might even be bad for some other reason. And if there isn't a review as required by the policy, the individual has a different remedy for that.
Yes, well, I just want to focus on the rules at the moment. What's the point in the rule requiring that reasons be given every month unless they're the product of a review?
Well, that is why I say that the review is clearly contemplated by the rule, but that is not what the text of the rule is directed towards.
I mean, you accept there's a public law duty to commit to carry out a monthly review.
Indeed.
And this rule supposes that it's going to be complied with.
Indeed. But the point that we make is that because the rules are of limited application, only to a proportion of immigration detainees, and because of where the context in which they sit, these rules can't form the route for finding any limitation in the validity of the Secretary of State's authority to detain, because that is actually the fundamental question for our case.
Well, if the rule then did contain the requirement that the Secretary of State shall conduct a review of the justification for detention on a monthly basis, would that make a difference?
It would make only this difference, which is that there would then be an explicit requirement to conduct a review. We say that for the purposes of this appeal, the result will be no different, because it is no different from the general public law duty to carry out a review in accordance with the published policy. You just find a separate route for getting there. It doesn't tell you anything about the remedy for a breach of that obligation.
Can one derive any benefit from Rule 9.2 as to what Rule 9.1 is getting at? Because Rule 9.2 entitles the individual to ask for an update on the progress of any relevant matter related to him, and I would have thought that's what the rule is, or what the reasons are all about. If you get them monthly, they'll be updated, and that's all part of the review, isn't it?
Yes, it is, and I don't seek to suggest that one should look at this in complete isolation from the fact that reviews ought to be taking place. But one of the arguments that is put against us is that because there is a breach of Rule 9, that is something that undermines the validity of the Secretary of State's authority to detain.
Title to the rule, of course, is detention reviews.
Yes. I entirely accept that. It shows that the contemplation that I've referred to. But it isn't, this rule isn't a route for undermining the validity of the authority to detain.
Nine 9.2, as explained under 9.3, I mean, that means that he's entitled to be told now he's getting on with his various applications to stay or whatever it may be.
Yeah. Can I then turn to the fourth place that you don't find a limitation on the validity of the detention authority, and that's in the policy. Policy is in Appendix 1, starting at 287. Can I just draw attention to a point which I promised to come back to, which relates to the IS 91. If you go to page 299, you'll see a description of the IS 91, the first paragraph starts with the risk assessment form, and then that must be attached to IS 91 and served on the detaining agent. This allows for the subject to be detained in their custody under Immigration Act powers. The IO must complete the first 3 sections of the form, transferring the assessment of risk as notified by DEPMU, that's the Detainee Escorting and Population Management Unit.
Where do we find...
It's actually left-hand side, about a quarter of the way down.
Yes, there it is. I see.
On to section 3, and so on and so forth. So there are a lot of administrative matters that are also recorded on the IS 91. And then the next paragraph, IS 91 is issued once and only once for any continuous period of detention, irrespective of how many detaining agents there are.
Detaining agents are what, sort of prison governors and people?
Prison governors, detention centres,
Yes, yes.
I think...
Escorts, presumably.
Escorts,
yes,
and so on and so forth.
Fine.
And if one looks at it, it's got of course, it's got a nice little series of boxes where you fill in who's been detaining.
Indeed.
Probably not the escorts, but the place.
Certainly the
down.
places of substantive detention. And then at the very bottom line, you see an accounting matter that is dealt with and that we've seen at the bottom of the 3rd page of the IS 91. So I promise to show you that description of what, or some of what the IS 91 actually does.
I mean, your proposition B4 may be absolutely fine, but you could have fooled some people by this document, couldn't you?
Well, we accept that there are references in the document to authorising continued detention. We say that that is obviously an understandable adoption.
Are there any the other way around, Mr. Taylor? Are there any which actually reflect the way you put the matter?
There are, and I'm going to come and show the...
You'll unearth some, will you?
Yes. If you can go
At
back...
the bottom of the first page, 287, the to be lawful, I mean, you seem to say, well, that's frankly wrong.
Well, this comes back to the place at which I started, which was that there are respects we accept in which you could describe unlawfulness in relation to the appellant's detention. The question is not whether there has been some breach of the law. We accept that, given what's happened, that's almost certainly the case. The question in this appeal is not that, it's whether the consequence is that he has a remedy of an action in false imprisonment. And that, we say, is something that you don't get from this document.
Sorry, but you're asking, at any given time, was his detention lawful? That's the question, isn't it? Or is that wrong? I thought that was the question.
Yes, but for false imprisonment, where one has what appears to be on its face an extant detention authority, which are the documents we've seen, you have to undermine those in some way. And what we respectfully say is that there's nothing in the policy document which suggests that it undermines the detention authority. This is an administrative policy. It's there to set out to say what should be done in order to make the decisions which have to be made. And
well, I'm terribly sorry, I mean, and to interrupt, but to press you, I mean, the last sentence says, to be lawful, detention must accord with the policy, i.e., you've got to have the relevant reviews. But you say that's absolutely nothing could be further from the truth. Public law duties by the dozen, but it's still a lawful detention. And you may be right, but I mean, that is a false statement on your submission.
In that sense, that statement is not wholly accurate. Well, can I say, I use those words advisedly because what we do know is there are cases like Nadaraja which show circumstances in which if you don't follow the policy, then detention is unlawful. So I'm not just trying that as a forensic trick either. If Nadaraja is right, then there are circumstances in which that is the consequence. But we respectfully say that if it's an omission to carry out a review, that is not the consequence, and in that sense, then yes, that sentence is wrong.
I see, but you would write, it must in certain circumstances accord with, but not in ours.
It must accord with paragraphs blah, blah, blah of this policy, but not with the others.
To be absolutely accurate, yes. Yes, that is right.
That would be the clear way of putting it, wouldn't it?
Well, it would be the legally accurate way, perhaps somebody might say legally pedantic way of putting it.
Well, it would have saved a lot of costs in this litigation, or possibly.
Well, you could be very, I'm sorry, just as if possible help to you, if you look at page 288, 38.1.1, maybe you only, the sentence only takes you as far as that, when you obviously accept there are implied limitations and its detention must be in accordance with the stated policy on the use of detention, and so on.
Yes.
It just depends how far you read that sentence as reading right through the entire document.
Indeed.
Where
Because
is the
point
stated policy on the use of it?
on the
Use of detention?
well, this contains, or at the time, contained the policy on the use of detention as well. So, for example,
It's the opposite page, is it?
Well, or
page 291, 38.3, factors influencing a decision to detain.
291, oh, I see, yes.
No, well, don't you mean 298? Or maybe you don't. No, maybe you don't. Policy on the use. No, I think I see you don't mean that, because that's just Article 5 and domestic case law. I mean, as I understand it, Article 5 and domestic case law doesn't say that there's got to be a risk of absconsion or anything like that before you can detain. Is that right?
That is right.
So
Established by SARDI both domestically and in Strasbourg.
quite. But government stated policy presumably says that if they're not going to be running away, you don't knock them up. So it's rather more restrictive, is that right?
That is right.
And where do we see that?
That's 291. Well, those are the factors, well, you see the way it's done: presumption in favour of release, strong grounds for believing that there'll be non-compliance. All reasonable alternatives must be considered. Once authorised, kept under close review, each case considered on its merits, and then the factors then set out. Sorry, for detention? The following factors must be taken into account when considering the need for initial or continued detention.
Can I just be clear? I hope it is clear to me from what you submitted that there is no species of detention that could properly be described as unlawful that would not give rise to a claim for false imprisonment.
Well, that is a case that is being put against us, and because the way the way the case is being put by the appellant and has been put throughout is, if you don't review my detention in accordance with the policy, that is unlawful, and it undermines the lawfulness of the detention, with the consequence that I have a claim in false imprisonment.
I do understand that, yes. But I'd like to have your submission as to whether there is any form of detention that could properly be described as unlawful, but would not give rise to a claim for false imprisonment.
Well, there certainly are, but in large measure it depends on what you mean by unlawful, and I think there may be a terminology problem here. Because
well, I put the example to you earlier, yes, of where bail had been granted,
yes,
but for some reason the order didn't reach the person doing the detaining, so...
Yes, indeed.
And that's clearly unlawful. That would clearly give rise to a claim for false
yes,
imprisonment, but you had difficulty accepting that.
Well,
clearly would, against somebody.
If the order to release on bail has the effect of undermining the detention authority, then yes, I would have to accept that
Well,
that makes the detention
I put
unlawful.
that as the clearest possible case.
Absolutely.
I'm sorry, I'm just cautious about taking a step in a direction where, with which this case isn't directly concerned, if we're talking about bail. But yes, I mean, there are certainly circumstances in which the authority to detain has been undermined and the detention is unlawful. But there are other respects in which detention might be said to be unlawful, which don't give rise to any action for damages. For example, the Hague type of case, where you could say that the detention was unlawful, looked at in a certain perspective, but it didn't give rise, in fact, it didn't give rise to any action for damages, let alone an action in false imprisonment.
Just remind us what happened there.
Segregation, thank you.
Sorry?
Segregation.
Segregated.
An individual segregated when he shouldn't have been.
Yeah.
But that's
But that's the
quality,
conditions
conditions
of detention that are unlawful, not the detention.
Not detention.
That was the whole point. It was segregation in breach of the prison rules, wasn't it?
Yes, that's right.
I mean, if you're in an open prison and then you're, I don't know, put in a straight cell, whatever, you know, one of those secure cells. I mean, that's not false imprisonment, even if they've no business to put you in it, or is it? I don't know. Don't think so, because once, I'm not sure. Can you have false imprisonment within a detained?
There is authority on that.
Is there?
Well, there's quite a lot of authority.
Yeah,
Hague being part of it and Munjaz being another part of it.
Well, Munjaz, but we decided that you couldn't have.
That's quite right, you do.
Yeah.
Yeah.
Even we do.
Yes. Well, no, I think we endorse what you said. Did we not? And part of what you said.
But there we go. That's life.
Yeah, I accept it. If the authority to detain has been undermined and the detention is unlawful in that sense, then traditionally that has been recognised as
But
a
is
false
there any
imprisonment
sense
claim.
in which detention can be properly described as unlawful, where a claim for false imprisonment would not be the inevitable consequence?
Well, if the authority for detention has been undermined, then that is a
Well,
consequence.
you make that distinction. What's the difference between the authority for detention being undermined and unlawful detention?
Perhaps the closest that one can get to that problem is the IPP cases, which we've called Walker, although coincidentally, that's how it's reported. I think that Walker was not one of the individuals before the court, where the problem that had arisen was in relation to the individual's opportunity to show that they were no longer dangerous and therefore satisfied the criteria for being released. But that was held not to allow, sorry, they were still lawfully detained because there the detention authority was the original sentence of the court, which still persisted. And so, as I say,
That doesn't really help, does
No,
it?
it doesn't really.
It
It was directed to Article 5, wasn't it? Anyway, and was there a common law claim in Walker?
yes.
Oh, there was,
There
was
was,
there?
yes.
Mm.
Yes.
But the terms of the warrant were not breached by the fact that the reviews had not been carried out.
That's right.
One of the lower courts had in fact said that it resulted in unlawful detention.
Yes.
They had found a case, but it was overturned by the Court of Appeal, and we in turn overturned the residual Article 5 claim. But I mean, as Mr. Hussain points out, I mean, that's a very different situation where there's a court sentence and then there is merely a parole board review mechanism for shortening it.
Well, can I come back to that under Article 5? Because in fact there is good and well-established Strasbourg authority to say that Article 5.1f detention is actually pretty close to 5.1a detention in terms of the link between the original authority and the occasion for detention and the detention itself. that actually, although Learned Friend Mr Hussain says, well, it's a very different case from 5.1a, it isn't actually, and Strasbourg has recognised that. But can I come back to that in when I come to the Article 5 submissions? I think I'm having some difficulty with Lord's question because, in a sense, that there may be an element of circularity in this. If the unlawfulness that has happened undermines the detention authority, then the consequence is false imprisonment. But there is that anterior question of, well, what is the effect of whatever unlawfulness there has been? Does it undermine the detention authority? And that is, I think, the question with which we're trying to grapple. But if you've got over that hurdle...
I think your answer is that there can be a breach of the law without transforming lawful detention into a condition of illegality.
Lord, yes. Yes.
But otherwise, your answer to his question is no.
So
So we're really looking at the effect of particular breaches of rules, policy, or whatever, which is exactly what I put to Mr Hussain on particular breaches of the Mental Health Act procedures. Some do and some don't render subsequent detention unlawful.
Lady, exactly so. And that is why we are at pains to identify the Roberts type of case, where you find it in the statute, the Evans type of case, where it's the sentence calculation, which is a very similar effect, and the contrast between those situations and the immigration situation here, looking at the statutory materials and the way that the system is set up and run.
Well, where do we go from here then?
I was just going to show you there are points in the policy. I'm sorry. Can I just finally, make a final point about that first sentence on page. The last sentence on page 287. One has to remember where that is found. It is the opening introductory section of an administrative policy which is intended to give directions to officials as to how things are to be done. And it contains perhaps an element of exhortation. Please do this, because otherwise the boss will be in trouble.
Indeed.
This case is about what sort of trouble?
Indeed. So it would be dangerous, we respectfully say, to take this one sentence and try and turn that into an exhaustive statement of the position in domestic or ECHR law as to whether and when a particular failure to follow these directions will give rise to a claim for false imprisonment.
Is the detainee who reads this document entitled to expect that if the policy is not followed, his detention will be regarded as unlawful?
With respect, no, because that must be a matter of law. That can't be set by a policy. He is entitled to expect that the directions will be followed. And as we've said, there are remedies that he undoubtedly has if those directions are not complied with. But we say that the policy can't itself change the law of false imprisonment. The whole of this policy must, of course, be read in its context, that it is an administrative policy. It could have been written in any number of ways, and the choice of language shouldn't be regarded as determinative, especially where it might be seized on to make all the difference between a claim lying and not lying. As examples that go in the opposite direction to those which learned friends point to, can I ask to look at page 295, paragraph 38.5 at the bottom of the page. The power in law to detain a legal entrant rests with the IO or the relevant non-warranted immigration caseworker under the authority of the Secretary of State. In practice, an officer of at least CIO rank or a senior caseworker must give authority. And then, so that's the initial detention. Yes. The contrast that we draw is that with the next one, detention must then be reviewed at regular intervals, 38.8.
Page 303.
And that's page
303.
303, where the first paragraph says initial detention must be authorised by CIO, HEO or Inspector SEO. Continued detention in all cases of persons in sole detention under Immigration Act powers must be subject to administrative review at regular intervals. So there's nothing in there, which is the statement of the basic position, to suggest that this administrative review is in fact a new detention authority, as my friend suggests.
Although one repeatedly finds those words in the documents that proceed from the operation of the policy,
yes,
as we've seen.
Well, to authorise continued detention. But what we say is one must be careful when looking at a document like this, which may well have been drafted with the statutory language in mind, but using the words to refer to a different concept. The authority with which this case is concerned is the legal authority given under Schedule 3 of the Immigration Act as authority to detain. Within an administrative structure, the officials concerned may well be giving, on behalf of the Secretary of State, instructions to do this, instructions to do that, and there may well be instructions within the department where the word authorised could equally well be used. And just because an individual official who is conducting a detention review and actually asking himself or herself the question, should this man now actually be released? And if the decision is no, as a matter of ordinary language, one could say, well, that is authorising the continuation of the detention. But that does not necessarily mean that what the official is doing is saying, I'm now re-exercising the legal power under Schedule 3 for a further period of detention.
The word authorise is used in the sixth last line on page 303, isn't it? And this is assuming there's been a change of circumstances during the period in between the weekly reviews. And there you see the word.
Yes. I think that the last paragraph may not be dependent on the bolded paragraph, but we can check that. But yes, I accept that the words authorised continued detention do get used in the document. But if one looks at the document as a whole, there's nothing to suggest that when this language is being used, it's intended to be used with the same effect as it is used in the statute, setting out the precise structure of how the detention power is to be exercised.
It's interesting though, isn't it? At each review, it's not described as you can decide whether or not the person should be released. That's not what it says. It says you can decide whether or not the person should continue to be detained.
Yes.
That's the whole tenor of this, because it's saying look for the continued grounds for detaining the person.
Indeed. And that, we respectfully say, is of course entirely consistent with an approach which seeks to minimise detention and to use it only when necessary, as set out in ordinary cases in the list of factors that we've looked at. If you're going to write a policy that tries to get your caseworkers to apply that, you might say to them, you're going to say detention should be maintained. But what you need to do is to ask yourself the question, what are they really doing? And the answer, we respectfully say, can only be what they're doing is considering whether to release, given the overall overarching statutory context that the detention authority is given at the beginning, And both by statute and by implied limitation, it continues to exist and continues to be exercisable at that time. The policy could just as easily have been written to say to caseworkers, you decide whether or not the individual should now be released. And perhaps one could pose a question, would that make all the difference in this case? There couldn't be any objection to a policy which said that, unless the statute itself says you must authorise only in chunks. If the statute doesn't say that, then the policy can perfectly legitimately say, at each review, ask yourself, should the individual now be released?
Mr. Tamati, what's starting to worry me in that is the difference between the Hardiel-Singh principles, which, as you say, consistently, even with Strasbourg, allow somebody to be kept in even if there's no risk of absconsion or any of that character. And yet the stated policy here is, as you say, more generous to the detainee than that. Look at page 291, factor 2. There must be strong grounds for believing a person won't comply with the conditions of temporary admission or temporary release for detention to be justified. Now, if therefore there are these reviews as there ought to be, there are going to be people who are let out more freely than under the Hardiel-Singh principles. And to agree, as is here agreed, merely that there wasn't any violation of the Hardiel-Singh principles is not necessarily to agree that there wouldn't have been releases under this more generous policy.
Yes, I think one would entirely accept that if the policy is more generous than Hardiel-Singh, as plainly it is.
Right, and therefore, if you lose the reviews to which the policy statement entitles you, you may well be, in fact, detained beyond a period when you should have been released under the policy, even though not contrary to Hardiel-Singh.
The way we say that one should analyse that situation is this. It goes back to the question of not of whether there is any unlawfulness, because if somebody doesn't get their detention review, and on that detention review applying the more generous policy, they might well have been released, what is their remedy? And we respectfully say that the remedy, and it's open to everybody, is to go to the court and ask for an order that the review take place, that the officials decide whether or not it should still be detention or whether it should now be release. And we entirely accept that if the review is not carried out in accordance with the policy and if the more generous detention policy is not applied, there may well be public law error in that. But that is only part of the way. What it doesn't get you to is the position where that undermines the detention authority that was issued at the beginning and which is otherwise still valid and still subsisting. And we say that that is a distinction. You can get other remedies, but false imprisonment and damages of false imprisonment are not the remedy in this situation.
If it takes a couple of months to get to court, and when you get to court, there's unambiguous evidence that if the review had been conducted timorously, you would have been released, let us say, 2 months earlier. Have you been lawfully detained in the interim?
We respectfully say yes. Your remedy is the order for the review to take place or the order for your release.
Even though you can establish that beyond peradventure that you would have been entitled to be released 2 months earlier.
You've not been falsely imprisoned during that period.
Yeah.
Does the policy actually tell us what is meant to be considered as a review, Mr. Tam?
I'm sorry.
Does it give us what actually we consider it? I mean, a whole lot of questions for detention at the first stage and so on. Do they just apply the same questions when they come to the review?
Yes.
Yes,
and that's the point of the sentence that learned friend
where's
Mr. Fordham asked to draw attention to on page 291.
Thank you very much. I didn't.
And that's sentence 4.
Four, is that, you take it,
Is
you
that
just
right?
apply the same over.
And the factors which are then listed apply to both 3 and 4, I suppose, whether justified and then whether it continues to be justified.
Yes, and then after 5, the next sentence is the following factors must be taken into account when considering the need for initial or continued detention.
Yes.
So that's what you look at when you're conducting the review.
Yes.
I mean, in practice, what is likely to change, apart from the length of time it's taking to get through this?
Well, some new factor may come to light, which makes the likelihood of the person being removed.
Maybe, maybe a mental health or something, illness or something like that.
Illness might be one thing. There may be a change in family circumstances,
Where is that?
or for that matter, there may be new evidence
Ties.
perhaps about their underlying claim, which could affect the likelihood that they would be
Right.
removed.
That's probably in practice the most likely thing to happen, isn't it?
Well, that is something that certainly does happen quite often. That people produce new evidence which is sufficient to show that they shouldn't continue to be detained.
Yes.
Yes.
And I'm looking at page 294 and 295. I mean, some of these factors which are listed there may not be immediately obvious at the start. And as we know, one of the reviews is after 24 hours. It may be that somebody's been brought in a hurry, and it becomes obvious that one or other of these factors which exclude make them unsuitable or whatever are present. So, yes. I mean, the initial period, these very rapid initial reviews are very important to see that the person is being properly identified as suitable for detention. Yes.
Well, it certainly can be, because in certain cases that something may come to light quickly.
I think this has to do with people detained under the fast-track process for processing immigration claims, isn't it? That's the Oakington detainees.
That's right. But in fact, this is exactly what was the subject of the case of D, decided by Mr. Justice Davis about medical examination within 24 hours to look for signs of torture, because if you had been tortured, you wouldn't be suitable for Oakington, and so that would be one thing that could well change.
Yes.
So we entirely accept that all of this is important, and all of this could have a real effect on whether you should continue to be detained or whether you should be released. But it doesn't answer the question, does it undermine the detention authority? And that we say it doesn't.
Would that be a convenient point to break in view of the time?
Well, I think if there's a couple of minutes,
yes, all right.
Just to finish up on this point, we say that there would be disadvantages if the policy were strictly construed and applied almost as if it were a statute. If, that is to say, if the policy says authorised continued detention, you take that as renewing the authority for detention in chunks. Because, as Mr. Hussain accepts, the executive can't make law, but that would be getting very close to it. That the executive deciding when an action for false imprisonment would or would not lie simply by the way in which policies were worded. That would be undesirable. It would also end up with policies being construed as if they were statutes, and that is also undesirable. They're not written for a legal audience, but for the guidance of officials. And in the longer term, there would be this damaging effect that if these policies were construed and applied strictly with draconian consequences in law, like an action for false imprisonment, they would tend, in the longer term, to be written more vaguely, to allow more room for leeway, for perhaps ranges of seniority of officers to look at reviews, wider bands for timescales of reviews, all of these to try and stop people falling off a hard, or stop officials falling off a hard edge and leading to legal trouble. But that goes quite contrary to what policies should be there to do, which is to give precise guidance so that the officials know what they're supposed to do. If this approach, this firm and strict approach to policies were to be adopted, there could in the long term be that damaging effect. And so we respectfully say that that's not the way in which policy should be approached. That would be convenient.
Thank you very much indeed. Well, we'll look forward to seeing you at 2 o'clock.